Good morning, let's try this again. It's Monday morning and this is the third time recording this. It seems the other two didn't save correctly. Well, anyway, I thought I'd start off the week today by discussing with you guys a little bit the eviction process and how that it works and what you can expect. It's not a fun process to let you know right off the bat, but it's a necessary process sometimes when a tenant refuses to pay rent or hasn't paid rent and they need to get out of the property so they can re-rent the property to somebody else. Usually when the tenant doesn't come in on the first day of the month to pay rent, your option is one, let them slide, see if they'll come in and pay it, or provide them with a 5-day notice or notice quit to pay. Basically, what that does, puts them on notice they have rent owing and due, the amount of rent that's due, late charges, fees that are there, outstanding balances, and I said, look, you either come in within the 5 days to pay the rent, or you vacate the property. If they don't vacate the property, then your next step is you end up in court seeking the property from them. And the 5-day notice process is just the beginning of that process. It puts them on notice, which is required by law. Then at the end of the 5 days they haven't paid, then what you do is you go ahead and you submit the paperwork either with the court as the owner, or if a property management company, you submit the paperwork through your attorney to the court. You're required to have, a property management company is required to have an attorney do the work. They cannot do it for the owner on your behalf. That's why there's authority given to them to hire and fire vendors in management agreements. With that being said, once you file paperwork with the courts, you are then required to serve notice on the tenant via a process server. If you use an attorney takes care of that. If you do it yourself, then you have to hire a process server, and usually there's a list of the courts that you can get of servers. I've done it both ways because I own property personally, and I also use an attorney. Now I use exclusively an attorney to handle the matters because I don't want to go down to court unless I absolutely have to. When that happens, the judge sets a court date, which is usually going to be 10 days from the time they didn't pay rent or the time that you gave them the first notice. So we gave it to them on the 1st, we're now on the 11th of the month if they haven't paid rent. Court's held, two things can happen. One, the tenant can say, look, I want to have a trial, and you go to trial. Make sure you bring your files, have good documentation, and you'll end up with a judgment and they'll still have to move out of the property. The other option is that the tenant will either agree that they owe the amount of money or there will be a no-show. In either situation, you'll get a judgment against them. Once a judgment is had and signed by the courts, justice of the peace, they'll be given a date they have to be out of the property, usually within 5 days. So now at the end of that 5 days, or 15 days. If they're not out of the property at that point in time, or haven't paid you, made other arrangements, then your next step is to call the constable out through a writ of restitution. The other is called a forcible detainer action. Or it might be reversed. I get the two confused all the time. But anyway, just know that in 15 days if they haven't moved out of the property, you have to go back to courts, petition them to have the constable come out and physically move them from the property. Once that happens, the constable gives you a call. The constable is like a police officer for the courts, not a city traffic officer. You can sometimes use a sheriff in outlying counties to do the same process. It usually costs you money to have the sheriff come out though. The constable as well too, but usually it's paid for by the attorney, included with the court costs. Well, when that happens, they'll give you a call, you got your change of locks, they'll kick you out of the property. If they have any belongings in the property, you'll have to store them. It's required by law for 21 days. I would recommend, if you don't have any fear they'll break back into the property, you leave them there instead of renting a storage facility and paying someone to move them. If you pay someone to move it and put it in storage, in order for the tenant to get out, they've got to pay reasonable storage fees and moving costs. They have to meet you in your time frame. If they don't pay those costs in the 21-day time period, you can dispose of the property as you deem fit, either through a public sale or if there's no value, throw it out. Let's see here. Getting back now, if the tenant is entitled to remove from the property things that he will need for his survival, immediate survival, such as passports, driver's license, medications, school books, kids clothing, some clothing for them, but they won't be allowed to take any furniture or anything if the constable comes up. That is unless you allow them to. Most situations, I will allow a tenant to take some stuff, or if it's 90% out of the property, take the remaining stuff out of the property, because I don't want to deal with it as a property manager. It's a cost that gets passed on to an owner, and the owner ends up having to pay that cost. And they have to seek payment from tenant at some point down the road to recover those costs. If all goes well, everything is fine, usually there's no problems when the constable comes out to the property. The whole entire process will take approximately 20-25 days depending on where it falls in the week and when you start it. But the good news is, unlike California and some other states, you can have the tenants out within 30 days or less. So with that being said, if you want to talk more about the process, how it works, either contact your attorney or give me a call at 480-699-9959, and I can give you some very basic information similar to what I've given you here. Maybe go in a little more detail on some things, but in all cases I'll probably recommend that you hire an attorney to take care of the matter, because you don't want to screw it up and have to start the process all over again. Well, thank you very much, and again, 480-699-9959.